Jeff, thanks so much for hopping on a call. It's been a wild last month, and we wanted to make sure we could debrief for everyone what is going on right now. So if you could give us an overview of where we were when the proclamation was first released and where we are today, I think that's a really good place to start.
We've come a long way. Just yesterday, USCIS and the Department of Homeland Security issued a long-awaited clarification to explain what they really meant in the presidential proclamation that went into effect on September 21st. And Danielle, it's all pretty much good news. It is now clear that any H-1B that was filed with USCIS, any H-1B petition filed prior to September 21st is not subject to the $100,000 fee. And any extension of that H-1B or amendment of that H-1B or change of employer application to a new employer based on an H-1B filed prior to September 21st also not subject to the $100,000 fee. But maybe the most exciting part of what was announced yesterday is what happens if one of these foreign nationals who is inside the United States and has a new petition filed after September 21st, what's happening with those? And now we know what the government intends. Number one, a new H-1B petition filed after September 21st also is not subject to the $100,000 fee as long as it's asking for a benefit for a foreign national who's inside the United States. So it could be an initial cap-exempt H-1B petition that can be filed anytime. It could be an H-1B petition filed next spring based on somebody winning the H-1B lottery who's inside the United States. It could be an amendment or a change of employer application filed for an H-1B non-immigrant who's inside the United States, even if it's filed after September 21st. And even more exciting is the announcement and clarification that if later on any of these people who were able to file an H-1B petition without paying the $100,000 fee while they were inside the United States, what if later on they're outside the United States and they're seeking entry? Maybe they're seeking a new H-1B visa at a consulate, or maybe they got the H-1B visa at the consulate, but now they're trying to enter the U.S. Yesterday's announcement makes it clear that they're not subject to the $100,000 fee. So who is subject to this fee? Foreign nationals who are outside the United States at the time of the initial H-1B petition filed after September 21st, 2025. These are very few of the total H-1B petitions that are filed every single year.
Let's pause there for 1 second. I just want to clarify who is no longer subject and make sure we're on the same page here. So at first we thought that anyone who was filing a change of status, which means that they're here on an L1 or an L1B, or they're here on an O1, or they're here on any other type of visa and they wanted to change to H-1B, or F-1, we thought that they were going to be subject to this fee even for just changing status while being here. And that was international students. That was really anyone who was seeking an H-1B. But now you're saying that this is not eligible. It is not applicable to anybody who is in the US and changing status, but rather only individuals who are outside the United States. And that's called consular processing. So what is going to happen for companies that do want to bring someone over here from outside the United States at this point? Is there any more clarification on that? Or are you, as an attorney, going to be trying to find other strategies?
It's only the people who are outside the United States whose initial H-1B petition is being filed while they're outside the United States.
Mhm.
Um, Let me give you an example. Someone might be outside the United States, but they already did have an H-1B petition filed for them prior to September 21. But now they're outside the United States and they haven't been in H-1B status for some time. Um, they are going to be subject to the $100,000 fee because this is a new petition
Yep,
and it's not an extension. It hasn't been a continuous H-1B situation. This is
yep.
a new petition. They will be subject to the $100,000 fee. And so for that person, we're looking for alternatives to H-1B. Maybe there's a way for the person to come. Maybe we can think if it's a legitimate J-1 research scholar kind of a situation. Maybe the person does qualify for an O-1 extraordinary ability. Um, we're looking for any possible way the person would qualify to come here without needing to pay the $100,000 fee.
Understood. So folks from outside the United States who, even if they have an employer that wants to bring them here and sponsor them on H-1B, even if they had a previous H-1B, if they're not actively on H-1B today, then they will have to pay that fee. So I assume
Yes.
you'll be looking at with those companies at L1s, at other strategies, O1s to bring those folks here, unless they qualify for a national interest exemption. And that's going to be really interesting to try to figure out who can prove the criteria. And USCIS outlined the criteria. Do you have it in front of you? I just posted about it on LinkedIn. But essentially, it's going to include that you have to demonstrate that you're in the national interest. And we don't know what that means quite yet. Is it going to be in line with the the NIW definition of national interest? Is it going to be in line with travel ban, previous exemptions of national interest? That's going to be the number one criteria. The number two criteria is that there is no US worker available to fill that role. So how is your firm thinking about proving that criteria, whether you're in the national interest and that there's no US worker? Because the other two criteria are that they don't pose a threat to the United States. So background check is pretty simple there. And the other one is that, this doesn't like significantly undermine the US. So it's really about those two first criteria that are going to be pretty significant to prove for companies.
Yeah. Well, I think the most difficult one will be to prove that there's no US worker
Right.
available to fill the role. Now, Danielle, that has always been the requirement for a green card
Yes.
process known as the Perm Labor Certification application.
Yeah.
Now, that is a 18-month to 24-month process to follow certain rules from the Department of Labor on how to prove there's no US worker available to fill a role. I am confident that this is not going to be required to
Right.
get one of these $100,000 fee exemptions for an H-1B. Because if that's what they wanted, they would have said so. And they would have
Yep.
laid out the rules of how to work with the Department of Labor to prove there's no US worker available. I think they're talking about something less. Here's what we do know. During Trump 1, when he had travel bans all over the place, there were national interest exemptions to those travel bans. And one could prove those exemptions by finding that the US federal government listed the particular area of work as a major national interest. Um, there's a federal organization called CISA, CISA, and at CISA.gov is a list of dozens and dozens of occupations and jobs that are within the national security and the national interest of the United States. And back during Trump 1, it wasn't that hard to match up an occupation with that government list
Yep.
and prove that it is in the national of interest waiver that this person have a travel exemption. Now we're talking about an exemption of the $100,000 fee. But in lieu of any other information from the federal government on how to prove this, that's what our law firm is going to start with
Great.
by matching these kinds of jobs up.
Yeah. That's great. I think that's really helpful for folks as they start to think about how they might qualify as a doctor, as an educator. Really, I think the CAP exempt organizations are going to be the first to try to test this, right? It's going to be the universities trying to hire foreign professors. It's going to be the hospitals trying to hire foreign doctors. We certainly at Build Fellowship are trying to hire foreign educators to come educate our students through our fellowship program in these high demand niche fields. So we're going to see those be the first cases, and I'm glad your firm's going to help us make that case to start out. We got a couple questions, and that I want to quickly mention. One of them, which came up multiple times in my LinkedIn post, about transferring to, like, coming to the United States on a B1, B2 visa, and then doing change of status to H-1B. My inclination is that this is exactly what USCIS is going to watch out for when they see a B1, B2 change of status petition to an H-1B, but I wanted to get your take on what you think might pass off as a legitimate change of status from B1, B2, as opposed to something that is going to be seen right through as a loophole for USCIS.
Right. That's a great question. First of all B1, B2s who enter the United States on a B1, B2 visa must be entering solely for visitor purposes or business meetings. They cannot be entering with the intent to change their status, and they can certainly not be entering with the intent to change their status to a work classification such as an H-1B. The State Department has a rule that if someone enters in B1, B2, and then waits 90 days before they apply to change status to any other classification, such as H-1B, if they wait the 90 days, it shall not be fraud. It shall not be a bar to changing to another status. USCIS has not adopted the same rule at all. What they say is that their officers have the right to investigate if they think there's fraud, but they're not saying one has to wait 90 days. Conversely, they're also not saying you're okay if you wait 90 days, that they still could investigate fraud. We think it's very dangerous to try to enter on a B1, B2 and change to H-1B. This will be a primary
Right.
investigative opportunity for Homeland Security to announce to the world that they're catching
Totally.
people trying to avoid to pay the $100,000 fee.
I bet especially if the foreign national works abroad for the company and they come to the US on a B1, B2, and that same company sponsors them for change of status H-1B, like they'll see right through that scenario. Do you agree with
Right.
that?
I agree. It's not a great idea.
Yeah.
There are sometimes the company's just going to have to pay the $100,000 fee.
Yeah.
But to avoid it, the better way is to avoid H-1B and look for
Yes.
those alternatives such as O1, L1,
Right.
possibly J1, E2.
Right.
Every case is different, and every case needs to go through that scrutiny. That's
Right.
what good immigration lawyers are all doing.
Yeah. Cool. So what's your takeaway where we are today? Are you feeling good about it? How do you feel about advising companies on H-1B right now? Are you still skeptical given Project Firewall is going to be coming up the pipeline in terms of new types of scrutiny over compliance? Or do you think it's going to be pretty much business as usual for H-1Bs?
It's not going to be business as usual for many people. It will be for my clients and the people you're working with at Build Fellowship, because everything is above board and legal and no one is hiding anything. And we, just like Build Fellowship, my law firm would welcome USCIS to investigate if they want to. Now,
Right.
it will be a problem for those who are cheating, and that's good news.
Yeah.
So I'm very optimistic about the current situation. I do still believe that the litigation that has been filed by multiple agencies suing the
Yes,
US government to stop the entire $100,000 program, I think it will prevail because even though it's been scaled back by yesterday's tremendous announcement, it's still unlawful.
yeah,
It is not in compliance with the law or regulations. The president is usurping the powers of Congress to make these rules about H-1B, and I think
yeah.
courts will throw it out. But I'm optimistic all around that business will keep humming along, and those who are not cheating and those who are doing it right and following the rules of H-1B and paying the right wage, all will be good.
Perfect. Yeah, that's really helpful. I'm going to make sure that we are able to share this message with other folks, and we'll probably hop back on to answer more questions that come up. But thanks for your time.
Sure, look forward to it next time.
Okay, take care. Bye.